Afternoon, everybody. We are here to get started on one of our healthcare compliance webinar series editions on information blocking. We're going to get started here in just a moment. All right, to stay on schedule, let's get started. Today, you're going to be hearing from myself, Amber Ellis. I'm one of the attorneys here at Holland & Hart on the healthcare team, and Kim Stanger, another attorney here. You've probably heard from him before. As I mentioned, today's presentation is for educational purposes only. It is not meant to constitute legal advice. If you do have specific questions about the application of this rule to your particular circumstances, please reach out to your legal counsel to get answers to those questions. So today we are looking at the information blocking rule. It's part of our healthcare compliance webinar series. We have a number of additional webinars coming up. You can take a look at the schedule on our website. We have about 2 a week, so take a look if there's any topics you're interested in. Sign up and you can join us. So today we're going to be talking about the information blocking rule. It is going to be a recorded program. We're not going to have time for questions based on the amount of content that we're going to try to cover. However, if you do have questions, feel free to submit them under the chat feature or email either one of us, and we'll respond to you after the program today. So don't hesitate to reach out if something does cross your mind. Here's a link to some of our written materials, a lot of great resources from the firm and also from the ONC. Take a look at them in your free time. Here's a screenshot of the ONC's website. There's a lot of really useful information on this website. If you haven't taken a look at it, I would encourage you to do so. There's some fact sheets and FAQs, and they are preparing more material as we go forward regarding the information blocking rule in particular. So why is the information blocking rule important? Penalties. So for developers, health information networks, and health information exchanges, the current proposed rule states that there are civil monetary penalties of up to $1 million per violation. And those are currently proposed. We'll see when the final rules come out exactly where they land on that. And for healthcare providers, there have not yet been any proposed rules, but we know that they will be coming and they will be appropriate disincentives to be established by HHS. So we'll know more about what those penalties will be in the future. And something worth noting, anyone can make a complaint to the ONC if they're concerned information blocking has occurred. So that particularly when we're talking about developers and health information networks and exchanges, that can include competitors who want to make sure that they're operating on a level playing field. So to back up a little bit, information blocking came originally from the 21st Century Cures Act, which was passed back in 2016. There were a number of goals that this act set out to achieve. A lot of them were related to addressing the opioid abuse crisis, but there was a provision in Title IV regarding information blocking that directed the Office of the National Coordinator for Health Information Technology, ONC, as we'll call it throughout, to promulgate rules to prohibit information blocking. So on May 1st of 2020, the ONC published its final rule. Now, at the same time, on May 1st, CMS also issued a rule that contains some information blocking provisions that is applicable to payers. We're not going to be covering that today, but that's something to be aware of if your organization has any components that may fall into the category of payers. The applicability dates for the information blocking rule have been a little bit of a moving target. Originally, they were set to take effect on November 2nd, and then on April 21st, in light of the COVID-19, health pandemic, the ONC did exercise its enforcement discretion to allow for extra time. And then on the eve of the November 2nd applicability date, an interim final rule was issued that further adjusted those applicability dates. So now the information blocking rule portion of the regulations that the ONC promulgated will become applicable starting April 5th, 2021. And one thing I'd like to note, this phrase interim final rule sort of suggests that there might be a final rule issuing, and that's not something that the ONC is required to do. Folks should move forward as if this interim final rule is the final rule because there is no requirement that an additional rule be issued. The ONC has the option, of course, to amend rules going forward or issue additional rules, but they're not required to. So operate as if this interim final rule is the final rule. So what is information blocking? So except as required by law or covered by an exception that's set forth in the rule, generally speaking, information blocking prohibits actors, which we'll discuss specifically who qualify as actors under the rule in a little bit, but it prohibits actors from engaging in any practice that's likely to interfere with, prevent, or material discourage access or otherwise inhibit the access, exchange, or use of electronic health information. So a few examples of what could be information blocking. Any practice that restricts access, including transitions between certified health information technologies, implementing health IT in non-standard ways that are likely to substantially increase the complexity or burden of accessing, exchanging, or using EHI. If there's a situation where an interface has to be built every single time another vendor tries to connect with a piece of software, that could potentially fall into that category. And then finally, implementing health IT in ways that are likely to restrict access, exchange, or use with respect to exporting data. And there's quite a bit of information in the regulations specific to requirements surrounding the exporting of data, or lead to fraud, waste, or abuse in delivering healthcare that is enabled by health IT. Now, there's a couple of other examples that are given. They're not meant to be exhaustive. They're just sort of to give you a flavor for what sorts of activities the government was concerned with when enacting these rules. So, high level, there are two standards that we want to look at when we are determining whether or not something could constitute information blocking. And there's a different mental standard that applies depending on the type of actor who is undertaking an activity. So if the activity is conducted by a health IT developer or a health information network and exchange, if that developer or HIN, HIE knows or should know that the practice is likely to interfere with the access, exchange, or use of EHI. So knows or should know for developers and HIN, HIEs. And if this activity is conducted by a healthcare provider, if the provider knows that such practice is unreasonable and is likely to interfere with, prevent, or materially discourage access, exchange, or use of EHI. Now, this is an important distinction because there's a different standard for folks in the business of healthcare technology versus folks whose primary business is the provision of healthcare. It's really important to pay attention to what your entity is functioning as, which of these different types of actors your entity is functioning as, because it is possible for a single entity to qualify as a healthcare provider in some circumstances, but they may also qualify as a health IT developer or health information network in other circumstances. And we'll look at that when we're looking at the definitions of actors. So there are three types of actors who need to follow the information blocking rule. So first of all, healthcare providers, and it's defined really broadly. You can see here, there is a long list of hospital, nursing facility, clinic, Group practice, pharmacist, pharmacy, all of these qualify as healthcare providers. And something I want to point out is that this is not limited to what we would consider a covered entity under Hipaa. It's a completely different definition that is not based on that covered entity definition. So I would look to the information blocking rules definition of healthcare provider when determining if you are an actor by virtue of that category. The second category is a developer of certified health IT. So that's going to be any individual or entity that develops or offers certified health IT. And there's one carve out for a healthcare provider that self-develops health IT for its own use. So a couple of things that I want to point out for you. So first of all, a developer of certified health IT, if that developer offers a single product or module that qualifies as certified health IT, that developer is a developer for purposes of the information blocking rule across its entire line of products. And that is something that the ONC spent quite a bit of time in the preamble discussing. There were comments into the proposed rule suggesting that the information blocking provisions be limited to the provision of certified health IT, and that was rejected by the ONC. They made it very clear that they were concerned that customers of a developer who has some certified health IT modules are going to presume that that developer is not going to be engaging in information blocking. And so for that reason and several others, they decided to make it clear if you're a developer, because you have a single instance of certified health IT, you are obligated to comply with the rule across your product line. Second, this does apply to entities who do not originally develop a product, but simply offer the product. And so this could come into play for some healthcare providers who are perhaps larger and have an electronic health record that they sublicense to other healthcare providers in the area so that folks are on the same platform and some smaller providers have access to that EHR system through a sublicense. So for purposes of offering that sublicense, they could be a developer of certified HT and have that heightened obligation above and beyond their obligation as a healthcare provider with respect to their activities specific to offering that certified health IT. So a couple nuances to this definition that it's important to be aware of. So third, health information networks or exchanges. So this will be an individual or entity that determines, controls, or has discretion to administer policies, agreements for the access, exchange, or use of EHI. And this is among two or more unaffiliated individuals or entities, and that is for a treatment, payment, or healthcare operations purpose as defined under Hipaa, but it's regardless of whether or not those unaffiliated individuals or entities are subject to Hipaa as either a covered entity or business associate. So again, this is a pretty broad net of what constitutes a health information network or exchange. A lot of discussion in the rules regarding the inclusion of the word individual in addition to entity, and it was just, they did not want to limit this in such a way that anyone was able to skirt out of the information blocking requirements. So broadly defined, you want to pay attention if you're an entity who possibly wears more than one hat for purposes of the information blocking rule, that you're thoughtful about what activities fall into what category and make sure you're complying with the relevant rules. So electronic health information, under the information blocking rule, it is defined rather broadly. It does not include, however, psychotherapy notes or information compiled in reasonable anticipation of litigation. So there is a carve out for some of that information. Now, there is a limited scope of the definition of EHI that is currently in place until October 6, 2022, and that is limiting EHI for purposes of information blocking to those data, classes, and elements as they're defined under the US CDI. And I've included a link here to a document that describes those different data classes and elements. There's been some changes. I think we talk about that on the next slide. It does replace the common clinical data set, so there are some new data classes. Allergies and intolerances, clinical notes is a big one. That includes chart notes, provenance, and some additional elements for patient demographics and vital signs. Now, this temporary definition of EHI that's limited to US CDI does not require that those interoperability elements are implemented at this time. It simply means that these data classes are available to requests to access EHI. It doesn't require that those interoperable elements are in place yet from a technological standpoint, just that the information representing these data classes is made available to the requester. So information blocking rule exceptions. We went through a couple of examples of things that could constitute information blocking. Those examples were made without regard to whether or not they might qualify for an exception. So there are eight exceptions overall. 3 of them involve fulfilling requests to access, exchange, or use HI. And then there are 5 that involve not fulfilling requests to access, exchange, or use EHI. So I'll go over the first 3. So first of all, there's the content and manner exception. And basically, this is meant to represent that if an actor responds to a request for specific EHI in the specific manner requested, such actions will not constitute information blocking. So you do have to meet both the content and manner components. So first, whatever content is requested by the requester. So if a patient is requesting one set of lab results, just because you have access to their entire chart doesn't mean you have to provide all of the chart. You can just provide the specific content that is requested. And then the access must be provided in any manner requested by the requester. In the cases where the actor is able to meet both of those criteria, it's not limited by fees and licensing exception conditions, which we'll discuss a little further on. So if you've got a vendor who's requesting a very sophisticated manner of transmitting the information, there's room for negotiation. And in fact, one of the goals of the content and manner exception was to allow negotiation of market terms for very specific and technical requests for information that may arise. Now, if an actor is not able to fulfill a specific request because they're technically unable or because they cannot reach agreeable terms, then the fee and license exception criteria apply. We're going to talk about those next. One of the interesting things about this particular exception is that it didn't actually appear in the proposed rule, but it did result from a lot of the comments that were concerned about interfering with the ability in the market to come to agreeable terms for purposes of accessing, exchanging, or using EHI. Under the fees exception, an actor may charge fees, including fees that result in a reasonable profit margin for accessing, exchanging, or using EHI, so long as those fees are based on appropriate conditions. And we'll talk about what constitute appropriate conditions in a moment. They're not based on inappropriate conditions, and they don't include any specifically excluded fees. Now, a couple of things about this exception. It came up in the preamble that it was definitely not the intention of the ONC to prevent actors from recovering the costs to develop technology and provide enhanced interoperability, because the concern was that would actually undermine the ultimate goals of the information blocking rule by diminishing incentives to invest in and develop interoperable technologies and services. So they did include this component that it is okay to include a reasonable profit margin. However, there are a number of limitations. So first of all, the fees must meet all of these following conditions. They must be based on an objective and verifiable criteria, and they must be uniformly applied for all similarly situated requesters. They must be reasonably related to the actor's cost of providing the access, exchange, or use of EHI. And they must be reasonably allocated among all similarly situated purposes or persons or entities to whom the technology or service is supplied. And this particular requirement here, be reasonably allocated, did raise a few comments and concerns. It sounds like potentially as a vendor's client base grows, they may need to adjust their fees to meet this particular prong of the fees exception. And that may be the case based on the commentary and this requirement being here. So it's something to stay on top of when assessing whether or not fees continue to meet this exception, sort of an ongoing review of the total number of clients and that there's a reasonable allocation made. And finally, they must be based on costs that are not otherwise recovered for the same instance of service to a provider and third party, so no double dipping. So a couple of things to consider. This specifically does allow some differences in tiered pricing, for example. If there's a certain price for 1 to 500 accounts and then a separate price for 501 to 1,000. That's possible as long as they apply equally to all similarly situated requesters. And one other item is this requirement does not require that all developers charge the same fee. There was explicit recognition that there may be completely legitimate reasons that would cause vendors providing similar but not identical products to charge different fees based on the quality of the product and how useful it is to the customers and how much it costs to actually develop that product. So there's not a specific formula, but there are some guidelines in this particular exception. Second, the fees cannot be based on any of these impermissible conditions. The first one is whether or not the requester is a competitor or a potential competitor. And throughout these exceptions, there is a string of rules and regulations that do not allow competitors to be treated disfavorably. This really encourages competition. And then secondarily, in this first requirement, the requester can't vary fees because the information may be used in a way that facilitates competition with the actor. Second, the fees cannot be based on the sales profit, revenue, or other value that the requester derives from the EHI. They need to be based on those 4 proper criteria on the slide prior to this one. And finally, fees can't be based on costs that the actor incurred because the health IT was designed or implemented in a non-standard way. And again, this is a common thread you see throughout the exceptions. It really wants to maximize interoperability and avoidance of developing things in a way that makes it more difficult to integrate or share information. A couple of more impermissible bases. The fees can't be associated with intangible assets, opportunity costs, or any costs that are being recovered by the actor pursuant to the licensing royalty in the next exception. So actor cannot recover its development costs twice. Finally, there are several types of fees that are not permissible. First, a fee charged to a patient for a request of his or her own protected health information is not protected by this exception. A fee that is based in any part on the electronic access by an individual, their PR, or another person to access their EHI. A fee to perform an export of EHI via the capability of certified health IT for the purposes of switching health IT. So this is another item in that common thread of promoting competition as opposed to suppressing it. And then finally, a fee to export or convert data from an EHR technology that was not agreed to in writing at the time the technology was acquired. And so if a contract on its face standing up an EHR system includes a provision that says, hey, look, there's going to be a fee if we have to export and convert, that's fine if it's done at the time that the technology is originally acquired. However, it's not something that can be sprung on an entity at the end of the relationship at the termination of that contract. The third exception is the licensing exception, and this provides that an actor may license interoperability elements when that practice meets all of the following conditions. So overall, the terms of the license must be reasonable and non-discriminatory. The royalties charged must meet the criteria outlined in the factors below, and they must be consistent with case law. So the conditions of the license must meet the following conditions. There must be a scope of rights included that will allow the requester to access, exchange, or use the EHI and achieve the intended access via the interoperability elements. A reasonable royalty may be charged if it's non-discriminatory, based solely on the independent value of the actor's technology and the licensee's products, and not on the value derived from the actor's control over essential means of accessing, exchanging, or using EHI. So this falls in the category of EHI cannot be held hostage for a price. If an actor has licensed the interoperability element through a standards developing organization, the royalty has to be consistent with those policies, and no royalty is allowable if the actor recovered any of those costs through the fee exception that was described above. So again, no double dipping. The licensing terms must be non-discriminatory, so they must be based on objective and verifiable criteria. This is similar to what we saw in the fees exception, and they must be uniformly applied for all similarly situated classes of persons, and they cannot be based on the fact that the requester is a competitor or the information could be used to facilitate competition, and they also cannot be based on revenue or other value that the actor may derive from access, exchange, or use. One of the provisions that is required to invoke the licensing exception is that the actor must begin to negotiate a license within 10 business days from the receipt of the request and complete the negotiation within 30 business days. And there are several items that are prohibited in order to qualify for the licensing exception. The actor cannot require in the contract that the licensee, the requester, not compete with the actor, deal exclusively with the actor, obtain additional licenses, products or services that are not related to the request for information when they can be unbundled. They can't require the licensee to license, grant, assign, or transfer the licensee's IP to the actor, and no fees other than the reasonable royalty can be charged. Now, there is a provision that allows the actor to require a reasonable non-disclosure that's no broader than necessary to prevent the unauthorized disclosure of the actor's trade secrets, so long as they state with particularity all the information that that actor believes to be a trade secret. So it needs to be pretty well defined what the actor deems to be a trade secret. Now, a couple of items about that reasonable royalty. You saw that a couple of times throughout this exception. There's not a lot in the rule that really describes what would constitute a reasonable royalty. However, in the preamble, there was a lengthy discussion identifying several factors, and the factors were actually pulled from case law. So some examples of what those factors in determining the reasonableness of a royalty are: how much are the royalties that the actor receives for licensing these proprietary elements in other circumstances? What are the rates that the licensee would typically pay in licensing comparable proprietary elements? What's the nature and scope of the license? What portion of profit is customary in the particular business? Other items are, what is the amount that a licensor and licensee would have agreed upon in an arm's length negotiation if they were considering these reasonable and non-discriminatory terms? And then finally, the last factor was, what's the opinion testimony of qualified experts? And as I stated, this came straight from the case law, so it will be interesting to see how the ONC comes out as they start interpreting this exception and determining what does in fact constitute reasonable royalties. So we'll have to wait and see on how they ultimately come down on these particular exceptions. And with that, I will turn it over to Kim to discuss exceptions that involve not fulfilling requests for EHI.
All right, thank you very much, Amber. Appreciate that summary so far. Now, just to get our bearings, as Amber mentioned, she was talking about those exceptions that involve procedures for fulfilling the request to access, exchange, or use the electronic health information. So those kind of what conditions you can and cannot put on that access. I'm going to be talking about the exceptions that apply when you decide you're not going to grant access or not going to share that information. And I want to emphasize that you're not required to fit within these exceptions, but these exceptions function as safe harbors. So if you satisfy these criteria that Amber talked about and that I'm going to talk about here, then you're safe. It's kind of like Stark or the anti-kickback statute, right? If you fit within those safe harbors, you're safe. If you don't, it doesn't mean that you've engaged in information blocking. It just means then it would come down to a question of whether or not your actions were reasonable under the particular circumstances. So with that said, let's talk about each one of the new exceptions. All right, the first one is the preventing harm exception. That makes sense, right? You shouldn't have to disclose the information if it could result in harm to individuals. And so the rule allows for this exception. So it's not information blocking if the actor has no reasonable belief that the practice will substantially reduce the risk of harm to the patient or another natural person, and you satisfy certain criteria. A couple of points on this. We're not talking about economic harm, folks. We're not talking about denying it because you think that it's going to adversely affect your position vis-a-vis a competitor. No, we're talking about actual, physical harm to patients or another natural person. In order to trigger this, the practice that you want to enforce must be no broader than necessary to substantially reduce the risk of harm, and that risk of harm has to be determined based on one of the two following criteria. First, it has to be determined on an individual basis by a licensed provider with the current or a past provider-patient relationship with the patient. Either that, or it has to arise, that risk of harm has to arise from data that is known or reasonably suspected to be misidentified, mismatched, corrupt due to technical failure, or erroneous for another reason. So that risk of harm has to generate from one of those two situations. In the case of an individualized determination, note that individualized determination isn't made by your IT director, right? That's made by a particular provider that they've looked at the case and they concluded, yeah, if we make this disclosure, then that could result in, physical harm to this particular patient or one of the harm standards. That determination, if you're going to rely on that determination under the patient under Hipaa has the right to have that determination reviewed by an independent healthcare provider per the particular Hipaa regulations. In addition to those criteria, there are additional criteria that have to be satisfied. The type of harm, it's not just any harm. The type of harm has to be one of those that would allow a covered entity to not deny access under certain HIPAA provisions, particularly those provisions at 45 CFR 164.524. Remember that HIPAA has a whole list of situations where you can deny access to the patient or the patient's personal representative because of risk of harm. Well, the information blocking rule kind of meshes with HIPAA and adopts those same types of standards. So you have to be able to show that there is this harm that could result to the individual if you make this disclosure. Now, the harm standard varies depending upon the particular situation, and it generally tracks the different standards that are applicable in 45 CFR 164.524. For example, if the patient is the one who's requesting the information, but a licensed provider determines that the access is reasonably likely to endanger the life or physical safety of the patient, then you may go ahead and deny the access both under HIPAA and under the information blocking rule. But note the standard that applies there. It has to be reasonably likely to endanger the life or physical safety of the individual. That's not necessarily just mental health or stress or something like that. Other situations have different harm standards, whether substantial harm or not. So just make sure you're aware of those requirements. In addition to satisfying those criteria to fit within this safe harbor, one of the following has to be satisfied. That practice, why you're denying that access, has to be consistent with an organizational policy that you've had in writing. That policy is based on relevant clinical, technical, and other expertise. It's implemented in a consistent, non-discriminatory manner and conforms to the other requirements of the exceptions under the information blocking rule. So it either has to be done per this written policy that you've already got, or if you don't have a written policy or the policy doesn't cover this particular situation, then that practice, that denial of the access has to be based on a determination that is based on a reasonably known facts and circumstances and based on expertise relevant to implementing the practice consistent with the requirements of the exception. So you can't just simply say, nah, we're not going to turn over this information because we think that it may result in harm. If you want the benefit of the safe harbor, you have to jump through these additional conditions. All right, the next exception is the privacy exception. And under this rule, it's not information blocking if you deny the request of an individual in order to protect an individual's privacy, so long as you satisfy one of the following sub-exceptions. Now, let's put this in context here. Remember that information blocking is defined in such a way so that it is not information blocking if you refuse to provide information because the law prohibits you from disclosing that information, right? That's just not information blocking, so you don't even need a safe harbor in that situation. The information blocking rule does not trump HIPAA. So to the extent that HIPAA prohibits you from making that disclosure, then you don't have to make the disclosure under the information blocking rule, right? On the other hand, to the extent that HIPAA permits you to make disclosures, then the information blocking rule may actually require you to make the disclosure or require it sooner than others. But to fit within this particular exception, you can deny the request in order to protect an individual's privacy so long as you satisfy one of the following sub-exceptions. And each of these are kind of like their own exception. Either the federal or state law requires the denial because certain preconditions for the disclosure have not been satisfied, or the disclosure is inconsistent with your IT policy, or you're a HIPAA-covered entity and that HIPAA-covered entity properly denies access, or the individual simply requests that their information not be shared. Let's talk about each one of those briefly. Under this first sub-exception, it applies if there's a federal or state law precondition for allowing access, but those conditions haven't been satisfied. So, for example, you've got HIPAA. HIPAA allows you to make disclosures if certain conditions are satisfied. For example, maybe if you get the patient's consent or authorization. Well, under the information blocking rule, it says, okay, you can rely on that exception if the preconditions have not been satisfied, so long as you satisfy certain additional criteria, that the actor's practice for denying that access is tailored to the law and is applied in a consistent, non-discriminatory manner, and either the practice conforms to the actor's written policies and procedures or the actor documents why the relevant criteria were not met. So if you determine that you cannot provide the information because it's contrary to law or the preconditions haven't been satisfied, you need to either have a policy or you need to have that determination explaining why the relevant criteria were not met. On the other hand, specifically, if it's a case where you can't provide the information because the patient hasn't provided a consent or authorization, the information blocking rule requires you to take reasonable steps to provide that consent or authorization to the individual so that they can provide the consent or authorization, and you can't improperly encourage or induce that individual to withhold that consent. Remember, the whole concept behind the information blocking rule is we want to have this exchange of health information. We think that's good for competition. We think that's good for patient care. We want to share that information. That's what the Cures Act is all about. And therefore, we don't want you guys getting in the way of sharing that information unnecessarily, including encouraging patients not to sign the consent or the authorization. In addition, if the actor is a health IT, this is the second exception. Remember, these are sub-exceptions. So the first one is if there's a federal law or state law that prevents you from disclosing them unless certain preconditions have been satisfied, you got to satisfy those conditions or take those steps. The second sub-exception is, well, if you've got an actor who's an IT developer and they're not a covered entity under HIPAA, they're not a business associate, they're not a covered entity, but they're otherwise seeking to protect the individual's privacy interests. They've got this, general privacy concern, and they want to protect their customers or the patients of their customers' data. Then they can go ahead and deny access so long as it is consistent with their internal privacy policies, and those privacy policies have been disclosed to their customers before their customers agreed to use that product, right? So they have to have these policies, they have to be disclosed, and those customers say, okay, we want to be able to maintain privacy consistent with these policies. The actor must implement the practices according to their own written policies. The policies must comply with the federal and state law, be tailored to specific privacy risks or interests that are being addressed, and be implemented in a consistent and non-discriminatory manner. So, well, what happens if you have a situation come up, you're an IT developer, you don't have a policy for this, you want to fit within the privacy exception, but you don't have the written policy. Can you provide or deny access? Well, you could, but you just may not be able to fit within this safe harbor. So if you're an IT developer and you want to fit within the safe harbor, you want to develop these privacy policies, get your customers to sign off on those in advance so you can take advantage of the safe harbor. The third sub-exception here applies if the actor is covered by HIPAA and the individual requests access per HIPAA, but the actors in this situation is basically under HIPAA, you're not required to provide the information under HIPAA. They basically incorporate this rule incorporates the HIPAA provision under 45 CFR 164.524, which allows covered entities and business associates, other entities who are covered by HIPAA, they can refuse to provide information, and that decision is unreviewable if the information is accepted from the individual's right of access. So if HIPAA doesn't require them, they're covered by HIPAA, HIPAA doesn't require them to give it, it's an unreviewable basis for denying access, then the information blocking rule says, okay, you can go ahead and do that. Well, what are those situations where you can deny access under HIPAA? Well, if the information is outside the scope of the right of access, because it's outside a designated record set, and remember, a designated record set are basically those records that are used to make decisions concerning an individual. Those aren't just healthcare decisions, those are any decisions about the individual. If it's outside that information that's used to make decisions about the individual, then it's outside the designated record set, the patient doesn't have a right of access, and you can deny their right of access under the information blocking rule if you're covered by HIPAA. There are certain other exceptions under HIPAA. For example, you don't have to disclose certain information from correctional facilities, certain research information, records that are subject to the Federal Privacy Act, or records that are obtained from another person under a promise of confidentiality. The fourth sub-exception is these are situations where the individual actually requests that the actor not share the information. So even though the information blocking rule wants information shared, they're still sensitive to privacy. And if the individual comes to you and says, hey, I don't want you to share my information, then you can go ahead and rely on that patient's request, so long as you satisfy a few conditions. The first is the government doesn't want you to improperly encourage patients to go out and deny the request. Maybe you've got some sensitive information, you don't want that competitor to get it, you know you're otherwise subject to the information blocking rule, so you can't go out to all of your patients and start telling them not to, to ask you to deny access to that information. So the individual has to request that the actor not share the information. The actor has to document the request within a reasonable period of time, and they don't specify exactly what that is. The actor's practice of denying that access has to be implemented in a consistent and non-discriminatory manner. For example, you don't discriminate against competitors, for example. And the actor may terminate that individual's request, meaning that if the patient requests that you not provide that information, the actor can't unilaterally terminate that request unless you satisfy some conditions. The first is if the individual terminates its request, the individual comes in and says, hey, it's okay, you can go ahead and share my information. In fact, I want you to do it now. Then you can go ahead and treat that request to limited information as terminated, so long as the individual requested that in writing, or they can request it orally. If they request it orally, you should document that their request to maintain the confidentiality has been terminated. Alternatively, if the law would allow you to make the disclosures, but the individual's asked you not to, but the law allows you then to go ahead and make the disclosures, you can go ahead and deny that the individual's request to keep that information confidential, so long as you inform the individual that you're going to terminate that request consistent with applicable federal and state law. And if you do that, that termination of that request only applies to the information that was created or received after the actor gave notice to the individual. So all of the information up until that time, you still got to maintain confidentiality per the individual's request. The information going forward after you gave the individual notice, then you can go ahead and provide access. That's similar to how it works under Hipaa. All right, the next exception is the security exception. This applies to situations where you need to, in order to protect your own security of your data, you need to deny access to somebody else. So in order to satisfy that, you've got to satisfy certain criteria. The first is that the practice has to be directly related to safeguarding the confidentiality, the integrity, and the availability of electronic information. That's the whole HIPAA security rule, right? That's its purpose. Your practice has to be tailored to specific security threat being addressed. So it has to be focused on the specific concern. The practice has to be implemented in a consistent and non-discriminatory manner. And if the actor has an organizational security policy relating to that practice, that policy has to satisfy certain conditions. It has to be in writing, have been prepared on the basis of and be directly responsive to security risks identified and assessed by the actor. It has to align with one or more of the applicable, other standards that justify it. It's got to provide objective timeframes and other parameters for identifying, responding to, and addressing the security incidents. Now, if your policy doesn't satisfy that, it doesn't necessarily mean that you're engaged in information blocking. It just means that you are not going to get the benefit of this particular safe harbor. Alternatively, that prior discussion applies if you have a policy. If the actor does not have an organizational security policy relating to a particular practice, then you can still go ahead and engage in this action without violating the information blocking rule, so long as the actor has made a determination in each case based on particular facts and circumstances that allowing access will provide a significant security threat, and that determination, that individualized determination concludes that the practice is necessary to mitigate that security risk, and there are no reasonable and appropriate alternatives to that practice that address that security risk and that are less likely to interfere with, prevent, or materially discourage access, exchange, or use of the information. So you got to use the less restrictive means to protect the security of that information. All right, the next exception applies. It's not information blocking if the access or sharing is not feasible. You simply can't do it, as shown by the following circumstances. It may be a situation where the actor cannot fulfill a request due to some uncontrollable event. Maybe it's a disaster, a public health emergency, there's a war, strike, whatever it is. It's something beyond their control. They can't fulfill the responsibility. It's simply infeasible. The second example is the actor cannot segment the requested information from other information that cannot be the other information that is limited. So you've got this group of information, the patient or this individual wants access to part of it, but other parts of it are protected by law, by the individual's request that it not be disclosed, or it would prevent harm. And if there's no way that you can go in there and segregate the two, so you can't disclose part of it without disclosing this protected stuff, then that is another situation where this infeasibility exception would apply. A third situation is if the actor documents the infeasibility due to certain consideration of certain factors or after considering certain factors. These are the things that are probably going to come up most often for you. Situations where you get this request, but it's just going to cost you a ton of money, or you don't have the physical resources to go in and provide this access. Well, this rule will allow you to deny that access so long as you document why you did what you did and it's otherwise reasonable. The factors you're going to want to consider are the type of the information requested, the cost of providing access, the actor's resources, both financially and technologically in providing the resources or providing that access, whether that practice is non-discriminatory, you're not just picking out this particular person because they're a competitor, whether the actor owns or has control over the relevant technology. So they can't provide access because we simply don't control that. In any of those situations where you don't provide it because it's infeasible under one of those circumstances we just described, you are affirmatively required to deny that request and provide to the requester a written response explaining the reasons why that request is infeasible within 10 days of the request. So you now have this time limit in order to explain your position to those persons seeking that request. All right, the last exception that we're going to talk about now is the health IT performance exception. This exception says it's not information blocking if the actor's practice is implemented to maintain or improve health IT performance, so long again as you satisfy certain requirements. There's two general circumstances that trigger this. The first is if the health IT is temporarily unavailable or affected because of ongoing maintenance. As long as that ongoing maintenance is not, put in place longer than is necessary or just a means around providing access, that maintenance is implemented in a consistent and non-discriminatory manner, and if it's implemented by an IT developer, health information exchange, or health information network, that it's consistent with your service level agreement. The other situation that applies to this health IT performance exception is if the actor may take action against a third-party application that is negatively impacting health IT performance. If the action is not taken longer than necessary to resolve negative impacts, it's implemented in a consistent and non-discriminatory manner, and it's consistent with the existing service level agreements where applicable. All right, that's a summary of the applicable exceptions. Again, I want to emphasize it is not absolutely essential that you fit within one of those exceptions. It just means that if you can't fit within those exceptions, then the question is, well, is the steps that you took to interfere with or delay or deny access Is it reasonable under the circumstances, or would it constitute information blocking? This slide provides a helpful summary of the information blocking analysis. Whether information blocking occurred in a particular case depends on whether, first, the individual or entity engaging in the practice is an actor, as defined in 45 CFR 171, as Amber talked about. So it only applies to actors, not everybody, but it only applies to just those actors that are identified in the statute, including the health IT developers, the HIEs, HINs, and providers. Second, did that request involve electronic health information as defined in the statute? Third, was the practice required by law? Because if the law prohibited you from making that disclosure or granting that access, then that's not information blocking. And you don't have to worry about getting to an exception. You comply with that other law. Fourth, the actor's practice. Did the actor's practice meet the conditions of an exception that we just talked about, right? If you did, then you're safe. If you didn't, it doesn't mean that you're engaged in information blocking. It just means that you would go through the analysis to determine whether or not your actions unreasonably interfered with the sharing of that information. Next, did the practice that you engaged in rise to the level of an interference under the statute or under the regulation? And finally, and this is an important one, I think, especially for providers, did the actor meet the requisite knowledge standard? As Amber talked about, the standard, that knowledge, that intent standard is different for providers and health IT developers. For health IT developers, HINs and HIEs, it's basically a know or should have known, right? They don't have to prove that you had improper intent. It's just, did you know or should have known that it should have interfered? With providers, it's a higher standard that the government would have to establish. They have to show that you know that that practice is unreasonable and is likely to interfere. It'll be interesting to watch for further developments because I think that will be an important defense to a lot of you who are providers wondering whether or not you're going to be subject to liability. Remember, you got to take this stuff seriously because of the potential fines that are coming down the pipe. Again, we don't have the final rule, but keep watch of that. So in the final few minutes, let's talk about next steps. We talked about what the rules are, what do you need to do? Well, first, look for opportunities to take advantage of the new rule. This new rule is going to allow you to access more data, both to provide effective care to your patients or for other permissible purposes. So rather than looking at this as a negative, you might want to look at this as a positive. How can we use this to get better information to allow us to provide better services? Because that's what the whole goal is, right? And those who are savvy business people may be able to turn this to your advantage and be able to provide more effective care and increase your share in the market. Next, you need to confirm your status as an actor. Are you just a healthcare provider, or are you also a health IT developer, HIN or HIE? As Amber mentioned, be aware of those situations where you are a healthcare provider. If you're just developing that software for your internal use, then that doesn't make you a health IT developer. But if you're sharing it with third parties, then that may make you a health IT developer, and the rules are different, including the intent standard. Next, identify and educate your stakeholders, those persons in your organization who need to know these rules so that they can implement them. Certainly your administration, but also your IT, your information systems, your medical records personnel, your compliance personnel, contracting personnel, marketing personnel, anybody who's going to be touching these requests to access information or contracts concerning your information, they need to be aware of this. Make sure they're aware of this. Next, review your EHR functionality. And maybe when you purchased that EHR, you turned off certain functionalities that would allow the sharing of that data. You need to go back in there and look and see whether or not you need to make modifications that are consistent with that information blocking rule. Next, you need to review relevant contracts to determine whether or not there are limits that violate the information blocking rule in your contracts. Things like, license restrictions or sharing data restrictions or trade secret restrictions, or those things that cross the line to information blocking. It may be necessary for you to go back and negotiate with your vendors if they're including improper contracts. You may need to educate them concerning these issues. Next, you need to review and modify your EHI practices, including how you handle requests for access or sharing that come from patients, requests for other healthcare providers or other third parties, to ensure that you're not only considering HIPAA, but you're also considering the information blocking rule. Because even though HIPAA may permit you to deny disclosures, if the information blocking rule requires you to do it, then you still may be required to do it. So you need to update your policies. Finally, you need to respond appropriately to requests for access to sharing. Make sure that you're complying with the rule, and watch for further developments, including further guidance concerning that knowledge standard for providers, the enforcement rules that we're going to be waiting for, further ONC direction as we move forward, the proposed HIPAA modifications. The government has issued a proposed rule that would modify the HIPAA privacy and security rules, in part to jibe or to mesh with the information blocking standards. So make sure you watch for that as it comes forward. All right, as far as additional resources, Amber mentioned the government's website. This is a great resource for a bunch of information concerning information blocking, including FAQs that they've updated. I think the last ones that they updated were on January 15th, but that can be a good source of help. The government's also published a bunch of fact sheets that are helpful. We've made a bunch of those available to you in the written materials we provided. We've also got additional information on our website for free if you would like to access any of that. All right, that is it. I apologize, we went 1 minute over. If you have any questions about the things that we talked about today, you're certainly not alone. Feel free to go ahead and shoot a question to us, either using the chat feature or an email directly to either Amber or I, and we will try to get back to you as soon as we can. Otherwise, thank you very much for your participation today. It's always good to talk to you, and I hope that this has been helpful.